Senator Escudero, Mr. President, before you.
The gentleman from Sorsogon.
Thank you, Mr. President. With the permission of the presiding officer, may I address some questions to the lead defense counsel, Attorney Cuevas? Sir, if I may ask, it is clear that the impeachment court already made a ruling with respect to the motion for preliminary hearing and even on the affirmative defenses itself with respect to the jurisdiction of the Senate and the procedure adopted by the House. The basic concern, Attorney Cuevas, is you might call all 188 signatories, and you might end up, being bogged down on this issue that has already been decided upon and ruled by the Senate. That's a basic and valid concern by the impeachment court, sir. And secondly, if it was for the purpose of establishing the absence or presence of probable cause, as mentioned by Senator Santiago and ruled by the court in its written ruling, that has already been disposed of by the impeachment court. However, if the purpose is perhaps to set the tone or to, by way of preliminary, to lay the predicate for your general theory of the case, and you will not present 188 and perhaps one or two witnesses on this matter, perhaps some understanding or bending over backwards may be given. But the concern again, Attorney Cuevas, is baka yung buong 188 ho ay patawag ho ninyo. Ano ho ang balak ninyo?
That is far from my mind, Your Honor, because our attack is not on the number first. Now, secondly, I hope you pardon me for disagreeing with your dissertation that there was already a ruling on this particular case. May I cite the January 12, 2012 dispositive portion? In view of all the foregoing, the motion for preliminary hearing filed by Chief Justice Renato Corona is denied for want of merit. So what was denied in our understanding, and it is clear to us, is only the right to a preliminary hearing, not the affirmative defenses, if Your Honor, please.
The court will decide on that, Attorney Cuevas. But may I get?
No, I'm just we have every reason to rely on this. If there was a categorical pronouncement, then probably we could have taken other remedies, if Your Honor, please.
But may we know, Attorney Cuevas, on this issue and on this matter, in the absence of a pre-trial wherein we would have obtained the list of witnesses, insofar as this issue is concerned, who and how many witnesses do you intend to present, if you may know?
Well, we have stated earlier that we are presenting about 20 witnesses, Your Honor, all the entire impeachment proceedings.
On this topic, sir, Your Honor.
Now, on this topic, probably 3 up to 5. Because, for instance, in 2/3, let's say there are this number, and 2 or 3 of them were intimidated or coerced to sign one way or the other. So the number representing at least 1/3 is already obliterated. So to us, that will be a facade of false information.
Mr. President,
Because you
Your
have
Honor,
a definite number in order to determine what is 1/3. Now, supposing of that 1/3, 1 or 2 were merely coerced, they were compelled to affix their signature without being voluntary on their part. Will that not at least change the color of their signature attached to the affixed to the complaint? That is because we have every reason to rely on the jurisprudence on the point. Since there is no definite article, much less any section of the impeachment rules by this honorable court, then we have to resort, or we have to go to other sources, Your Honor. And we are not totally left without any support whatsoever. What we read into the records are questions where the impeachment complaint was filed by at least 1/3. And to us, it is clear that the mere fact that the complaint is verified complaint was filed by at least 1/3 does not exempt the petitioner or the complainant from observing the requirements prescribed by law in order to comply with the requirements of due process. That is our point. Because left with no alternative, where do we go? There is no appeal. But there is a violation of the constitutional right of the accused. That is therefore a ground for the Supreme Court to take cognizance of the case. If that is a ground, then how else could we assert it? Except by pleadings. And if we do not agree with the decision of we do not agree with the decision of the Honorable Impeachment Court, then maybe other remedies are available to us.
Mr. President, for the record, I agree with the impeachment court with respect to the non-issuance of subpoena to members of the House. However, nothing bars a member of the House from testifying voluntarily if they are called by the defense as their witness.
No.
And insofar as allowing the defense to present evidence on this matter, for as long as it is on a short leash and will not entail the calling of all 188 of them, which would be unreasonable to say the least, and I think Council will agree with me.
Yeah, we have already. I'm sorry.
For the record, Mr. President, Your Honor, that is the position of this representation, so that the defense can be given some leeway with respect to developing their case.
I'm
on the
not
matter.
yet crying for liberality in favor of the impeached public official. Many a times, the prosecution had been crying for the extension of liberality on their part. If there is anybody who should cry or call for liberality, it should be the impeached public official, being the accused in a criminal case. Never is there a time where the prosecution asked for liberality. I was a fiscal for more than 20 years. I never asked for any liberality.
We submit and we thank the distinguished counsel for the defense for his
Thank you. Now,
patience,
may
Mr.
we
President,
pose a
Your Honor.
question, if Your Honor, please? We have 3 members of the House of Representatives whom we intend to utilize as adverse witnesses, Your Honor. If we call for a subpoena, if we ask for a subpoena to compel their appearance, Your Honor, it may again fall under the previous ruling of this Honorable Court. But this time, we are not calling them as ordinary witnesses, Your Honor. They are calling them as adverse party, and the law allows us under the rules of court, Your Honor.
Who are the adverse party that you want to...
For instance, Congressman Abaya, Your Honor, Congressman Kimpo, and Congressman Tanyada, Your Honor. And then we will dispense with
Mr. President, may we
Congressman
recognize,
Gonzales. We are calling them not in their capacity as congressman, Your Honor, but in their capacity as complainants, Your Honor. So they are adverse party, Your Honor. If the court will not lend its assistance to us, we'll have no alternative. We cannot compel them to come here.
All right.
Mr. President, may we recognize